On the record, in the matter of the people of the city of Lansing versus Todd Michael Dinsborn in file number 21-01611 OD, appearance please.
Assistant Defender Lauren Sutter on behalf of Mr. Dinsborn, who joins us via Zoom.
Our courtroom was muted, so I didn't hear anything.
Good afternoon, Your Honor. Martin Vasquez, your city of Lansing.
Okay, today was the date set for a probation violation hearing for Mr. Dinsborn. And my understanding is that there will not be a contested hearing to the violations.
That's correct, Your Honor.
Okay, so Mr. Dinsborn wants to enter a guilty plea to the alleged violation that he failed to complete the sobriety court program as directed at 54B District Court.
Correct, Your Honor.
Is that correct, Mr. Dinsborn?
Yes, Your Honor.
Please raise your right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury?
I do.
Okay, you can put your hand down. Okay, Mr. Dinsborn, you were advised at the time of your arraignment of your right to have a contested hearing on these violations or on this violation. You are represented by counsel. Did you wish to give up your right to have a contested hearing today?
I do, Your Honor.
Is anybody threatening you or forcing you to give up that right?
No, Your Honor.
You're giving that right up freely and voluntarily?
Yes, Your Honor.
Okay. I understand that by entering a guilty plea to the violation, it could result in sentencing. You understand that?
I do.
Okay. As to the violation that you failed to complete sobriety court at the 54B District Court as ordered, how do you plead?
Guilty,
Your Honor.
Can I have a factual basis, counsel?
Yes, Your Honor. Thank you. Mr. Dinsborn, is it true that on April 18th of 2022, you underwent sentencing with Judge Simmons?
Yes, that's true.
And during that sentencing, were you ordered to comply with all the terms and conditions of the 54B sobriety court?
Yes, I was.
And is it true that as of the filing of today's violation that you were not in compliance with the 54B sobriety court?
I did not complete successfully.
You've been terminated at this point, correct?
Yes.
Thank you, Your Honor. I believe that satisfies the factual basis.
Does the city have any questions?
No questions from the city, Your Honor.
The court is satisfied with your plea. I'll accept it. I find it to be freely, voluntarily, and intelligently given. I received a recommendation from probation. In addition to that, I was in receipt of a letter from Judge Greenwald from 54B District Court, who supervised Mr. Dinsborn during the time of his term of probation through the specialty court. First, the recommendation from our probation department, was obviously to terminate the probation status, excuse me, and that jail time was minimally suggested as Mr. Dinsborn is currently in inpatient treatment. And it said the defendant did not complete the 54B sobriety court successfully. He had several relapses throughout the time of the 2-year period. And it is recommended that his sentence run concurrent with this 54B sentence. The information that Judge Greenwald provided to the court was very insightful. She indicated that Mr. Dinsborn, that she obviously got to know Mr. Dinsborn well during the term of the 2 years that he did participate in the program. And she said that she got a feeling that Mr. Dinsborn wants sobriety and that he understands that he needs sobriety in order to stay alive. But he made significant progress in sobriety, physical and mental health, relationships, and career, that he did have several relapses, and that she could say with certainty that one thing about Mr. Dinsborn is that he did not ever stop trying. And so she also indicated that sometimes, because obviously the road to recovery is a unique road, that sometimes 2 years is just not enough. And she thinks that this is one of those situations where 2 years just was not enough. Obviously, Mr. Dinsborn is appearing today remotely because he's still on his road to recovery, which is what we want for you, Mr. Dinsborn. It's unfortunate that we couldn't resolve this another way today, but the positives is that your journey hasn't ended it's in regards to your steps toward having full recovery. And so I am going to encourage you, hopefully, that you will continue what you're doing, which is fighting so that you can be healthy and whole, and that you're continuing to get the resources that are being extended to you to help support you in your recovery process. I have no information as it relates to what he's got going on in 54B. However, I am just going to discharge him from probation, and understanding that he did not complete the program for specialty court. That in and of itself has its own impact, because as he recovers and Mr. Dinsborn, as you're looking to move forward in society, obviously this will have some impact on your ability to get your license, because you haven't been able to successfully complete these specialty court. Doesn't mean you won't be able to get your license. It's just more of an uphill battle for you. But that's not even something I think that is at the forefront or should be at the forefront of your mind. You want to get healthy first, and then when the time is appropriate, you'll find a way to show the Secretary of State that it's time for you to now regain your privileges as it relates to driving. So as it relates for this court, we'll discharge you unsuccessfully from the probation status and from the specialty court status, and that'll resolve the matter. I don't know if he had outstanding fines and costs. Can someone advise?
Yes, Your Honor, he does. I believe he has two files. One is actually set before the court for a probation violation on the exact same thing next Tuesday. On one of the files, he has an outstanding balance of $1,283.10, and on the other file, he has a $0 balance. And I believe it is the balance that is the hearing today is the one that has the remaining balance of $1,283.10.
Can someone in the courtroom confirm, please?
That's correct.
Okay. And so we'll refer that to collections. We'll set that, sir, for a show cause hearing. How long do you expect to be in inpatient treatment?
At least a year.
Okay, can I get a show cause date 6 months out so we can follow up on the status of payment plans on this?
May 20th at 1:15.
We'll set it for show cause May 20th at 1:15. And we'll send a notice to the last address that we have for you, Mr. Dinsborn, unless you have another address that you want us to send your notice for.
I do have a different address. I gave it to Mr. Hannah, but I can give it to the court today.
Okay, if you gave it to Mr. Hannah, then it should be in the file.
Okay.
Do you have any questions for the court at this time?
I don't, Your Honor. So I appear again on the 26th for the same thing, and
In your other file, correct.
okay. And yeah, I'll definitely have that paid off within 6 months, and I'm just grateful for the court's understanding. I'm celebrating 2 months today, and looking to keep going.
Thank you. Well, that's good progress, and good luck to you as you enter into the holiday season. I want you to stay encouraged and still head forward towards your recovery. Okay, sir?
Thank you so much, Your Honor.
Thank you. Have a good rest of your day.
Thank you.
You're welcome. Okay, and do we see Mr. Vu?
Yes, he's here.
Okay. On the record in the matter of the City of Lansing versus John Vu, and this is file number 23-01605. Appearance for the record, please.
Good morning. Good afternoon, Your Honor. Vasquez for City of Lansing.
Okay, Mr. Vu, state your name, please.
John Wu.
Mr. Vu, today was the date that I reset this matter that was scheduled for a hearing on a probation violation. My understanding is that you were denied public defense counsel and you appealed and you were denied again. They said there was no change in your financial status. So you have one of two options today, sir. You can proceed to represent yourself, or if you want to have time to hire an attorney, you can do that at this time. I don't know what your plans are as to representation, though. What do you want to do, sir?
I will represent myself.
Okay. Have you spoken with the city attorney today on this?
Yes, a little bit.
Okay. Are we going to have a contested hearing today?
No, Your Honor.
Okay, Mr. Vu, you want to enter a guilty plea to the violation?
Yes, guilty.
Okay, let me have you raise your right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury?
Yes.
Okay, you can put your hand down. Okay, and Mr. Vu, you do understand your right to counsel. You're going to effectively waive your right to be represented by an attorney today?
Yes.
Okay, and you also understand that you have the right to have a contested hearing on the violation that you were previously arraigned on. Again, that violation was that you tested positive for alcohol with a ETG of 718 nanogram per milliliter at AverHealth back on October 2nd, 2024. So you understand that you can have that contested hearing today?
Yes.
And you understand that you could require the prosecution, that being the city attorney's office and the probation department, to put forth evidence that would establish your guilt as to that violation?
Yes.
You want to waive your right to that hearing, sir?
Yes.
Does anybody threaten you to do that?
No.
Any promises being extended to you if you waive your hearing?
No.
As to the violation that alleges that you tested positive for alcohol at AverHealth on October 2nd with a ETG of 718 nanogram per milliliter, how do you plead?
Guilty.
You were placed on a term of probation before the 54A district court, is that correct?
Yes.
I put you on a term of probation, sir?
Yes.
And part of the terms of your probation was that you could not have or use alcohol or controlled substance unless you had a valid prescription?
Yes.
And were you also ordered to test as part of your probation status?
Yes.
Okay, were you ordered to test on or about October 2nd, 2024?
Repeat.
Were you ordered to go and do a urinalysis testing back on October 2nd, 2024?
Yes.
Okay, and prior to that, did you consume alcohol?
Yes.
Okay, what did you consume, sir?
Just beer.
You were drinking beer. You knew it was beer when you were drinking it?
Yes.
You knew it was in violation of your probation status?
Yes.
Okay. Any questions from the city?
No questions from the city, Your Honor.
The court is satisfied with the factual basis. I'll accept your plea. Find your plea to be freely, voluntarily, and intelligently made. Let me see here. Ms. Collins, did you send me the recommendation from the file?
Yeah, yes, I did. I can resend it.
I have not received it. Okay, the probation department has recommended that the defendant continue probation at this time and that the court impose a weekend in jail for the violation. He's scheduled to be on probation at this point until February 8th, 2025. And they want to add a scrambling for the next 60 days. It says the defendant's overall attitude has been good. The acceptance of responsibility has been fair, and overall progress has been fair. So the defendant tested positive for alcohol, and that this was the second violation where the defendant tested positive, even though it says technical violation number 1 at the top of the form. That's a little inconsistent. It says defendant has had issues throughout probation with normal creatine tests and possibly hiding alcohol use. I'm sorry, Mr. Vu. Did you want to say anything to the court before the court imposes sentencing?
No.
You said that, so no?
Yeah, I don't really have anything to say at the moment.
You don't have anything to say at the moment? Okay. Mr. Vu, are you working?
Yes. If possible, can we avoid jail time so I don't lose my job?
Where do you work?
I work at Shift Group in Helen Sherlock.
What is that?
We build Isuzu trucks, and we do like mobile homes and Amazon trucks and FedEx trucks.
When do you work?
I start work at 5 o'clock until 3:30 in the morning.
What days do you work?
5 days a week, sometimes 6 days, it depending, but we don't know on the 6th day until like towards the end of the week, like on the Thursday, Friday.
The recommendation was for you to do a weekend in jail. You understood that?
Yes.
Okay. I was not going to impose the weekend up front. I'm going to hold it over your head. What we want you to do, sir, is we want you to comply with not drinking when you're not supposed to be drinking because you're on a probation status for a matter that involves drinking. You understand that? We tried to give you some tools and some court-ordered programming to help you, and that's not quite sufficient. And we'll try some other methods, but if it doesn't work, if you can't follow the court order and you just can't stay away from alcohol, then we don't have a choice but to try another avenue. You understand that?
Yes.
And so sometimes you can make a decision that puts the court in the position where we can't avoid putting you in jail, and that's because you won't comply and you're engaging in activities and decision making that's detrimental not only to your health but to those that are around you. Do you understand that?
Yes.
I'm going to impose 7 days Ingham County Jail. I'll hold that in abeyance, meaning it'll be suspended upon successful completion of your probation with no further violations. You're going to continue your probation at this time. I'm going to add scram tether. You're going to wear the scram tether until the time, at this point, you're supposed to be discharged on February 8th. I'm going to give you scram tether for the next 90 days. So you need to go down and see Mr. Hanna so you can get information on where you go get your scram tether, okay?
Okay.
Any violations of alcohol use, again, sir, you'll have to go to jail. And if that has an effect on your employment status, you can remember that you were the one who made the decision to put yourself in a position to risk your livelihood by risking your job. You understand that?
Yes.
Do you have any questions at this time?
No, Your Honor.
You can go down and with Mr. Hannah before you leave. Any additional matters for the record, counsel?
Nothing from the city, Your Honor.
Thank you. You're all set, Mr. Vu. Okay, on the record, the matter of the people of the city of Lansing versus Daquan Tatum. This is file number 22-03189. Excuse me, Mr. Tatum, can you hear me?
Yes, I can hear you.
Okay, very good. Okay, Mr. Tatum, today's the date that was scheduled for a probation violation arraignment. I have a request in summons for probation violation. It alleges that you committed the following technical probation violations. It says per number 13 or paragraph 13 of your order for probation that you tested positive for alcohol.
Yeah.
With an ETG of 25,000 nanogram per milliliter and a THC level of 0.948 nanogram per milliliter back on September 26, 2024. It also alleges a violation of section 16 of your probation order, which states that you failed to enroll in outpatient substance use treatment as ordered by the court. So you have the right to have a contested hearing. You have the right to be represented by an attorney at that hearing, and you have the right to have the city and the probation put forth evidence to establish your guilt as to those violations. Do you want to request an attorney to be appointed to represent you, sir?
No.
Okay, you want to waive your right to have an attorney represent you?
Yes.
Okay, do you want to have a contested hearing?
No.
You understand that by waiving your contested hearing, you could be sentenced to jail time?
Yeah.
Okay. Anybody threatening you to get you to give up your right to your hearing or your right to counsel?
No.
Okay. Raise your right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury?
Yes.
Okay, you can put your hand down. Ms. Collins, is there a recommendation in the file?
She left out, but I thought she said she sent all of them.
She sent the ROA and she sent the request and summons from Mr. Tatum. I don't have a recommendation. If there wasn't one in the file, his probation officer could log in.
Sent it over.
Thank you. Okay. And so again, Ms. Tatum, I've advised you of the violations. There's two violations here, technical violations. One that you tested positive.
Truly, I haven't smoked weed. I've been around it or whatever, but I haven't smoked no weed in a while. I'm not sure how that even
Okay,
happened.
well, there's two technical violations. One is that you tested positive for alcohol and THC. They actually wrote that as one violation. And then the other violation being that you failed to enroll in outpatient substance use treatment as directed. You understand that that's two separate violations, sir?
Yes. Yeah.
And you want to plead guilty to both of those violations?
Yes.
Okay. As to the violation that you tested positive for alcohol on September 26th, you're pleading guilty to the portion that says you test positive for alcohol, but not to the portion that says that you had THC in your system, 948 nanogram per milliliter. Is that accurate?
I'm not. It's saying that, but I'm just saying I'm not sure. But I'm disagree with it.
Well, my question is, okay, so you're pleading guilty to the alcohol portion. You are going to admit that you drank alcohol. Is that correct?
Yes.
But you're saying that you're not admitting to the
Smoking.
THC, but
Yeah.
you do admit based on your statements, that you were around THC?
Yeah,
So that means you were around someone that was smoking THC?
yeah. Like everybody I really know smoke weed.
Okay. Okay. As to the alcohol, what did you do on or about September 26th that made you guilty of consumption of alcohol?
Going through trauma with the family, and just it's like a stress reliever for real.
What is a stress reliever? I asked you,
Taking
what
a
did
drink.
make you guilty? Going through trauma doesn't make you guilty, and having a stress reliever doesn't make you guilty. But what made you guilty would be if you drank alcohol. Did you drink alcohol?
Yes, yes,
And you were placed on the term of probation by me for the 54A District Court?
yes,
Okay, and that was for an alcohol-related offense, correct?
yes,
And you were told that you were not to use, purchase, or possess alcohol or drugs without a valid prescription. Is that accurate?
yes,
And so on or about September 26th, were you ordered to do a urinalysis testing?
yes,
And you have been drinking alcohol prior to that?
yes.
You also had been around some people. You said everybody around you smokes weed?
Most everybody, yeah.
Okay, and so you're aware, or you should be aware, of the term of a contact. You're familiar with that?
Yes, yeah.
Okay, so you understand that if you're in an area where someone's smoking weed, you can have a contact, meaning you can have the effects because of being in contact with someone else who's smoking it, correct?
Yes,
Okay, but as to the alcohol, you knew you were drinking alcohol when you drank it?
yes,
You knew it was in violation of your probation status?
yes,
And then as to the violation that you failed to enroll in outpatient substance use treatment as directed, you're pleading guilty to that as well?
yes.
Okay, and have you enrolled in outpatient substance use treatment?
I haven't. I work third shift, and by the time I get home, I gotta take my son to school, and I just be tired. That's my honest opinion.
Your honest opinion?
Yeah,
Okay, so you were ordered to do substance abuse treatment by this court. You work third shift, so that means you work 11 to 7?
10 or 7.
10 to 7? So you're home at 7 and you take your child to school and you still aren't doing your substance abuse
No,
treatment?
I don't get home till like about 8.
Okay, 8 o'clock in the morning, and then you take your child to school, and then you still don't do your substance abuse treatment?
Nah, I be tired.
Oh, okay.
I like be falling asleep on the bus and stuff, like all type of stuff.
Mm-hmm. Okay. But you're not too tired when it comes time to drink alcohol?
The little time that I was awake, I guess.
Okay. The court's gonna accept your plea. I find your plea to be freely, voluntarily, and intelligently made. The recommendation here, this is your second technical violation. The recommendation is for you to do 4 days in Ingham County Jail.
Mm-hmm.
The defendant tested once and was positive for cannabis and alcohol. He denies substance use. They're requesting that your time or amounts of testing increase and that jail time be held in abeyance for the recommendation. Is there anything that you want to say before I decide how you're going to be sentenced?
I have Sundays and Mondays off of work.
Why do I care?
I really need my job.
Yeah, you have to think about that when you're making decisions that are contrary to the court order, because being on probation is not your right, okay? If you want to keep your job, if you want to stay out of jail so that you can be there for your son, your only option is to follow the court order. That's a decision that you have made. And the decision that puts you in this position is that you were operating while intoxicated. So you had an alcohol-related offense that put you here in the first place. These are all for your actions. If the court has ordered you to do substance abuse treatment, you can't come in here and tell me as an excuse that you're just too tired to do it, and that's just your opinion. Because if that is just going to be your opinion, then the opinion of the court is that I'll enter an order that you do 93 days in jail. Do you understand that?
Yeah.
So those are your options. You're going to do 93 days in jail, or you're going to do substance abuse treatment.
Okay.
I could care less about how tired you are. Get some coffee. Because you have all day to take a nap in between doing your substance abuse treatment. The substance abuse treatment ain't all day. It's not all day. And you're not going to make me believe that every single day of the week that all you're doing is going to work and taking your child to school, and then you're sleeping for the rest of the entirety of the day until it's time to go to work. If you are, then you probably need to get some medical help about why you're so tired. Either way, tired or not, you have a responsibility to follow the court order. And if you can't seem to bring yourself to make that a priority for yourself, then I can help you prioritize that. Do you understand that?
Yes.
The sentence of the court is, I'll continue your probation. You're supposed to be on probation until the March 17th of 2025. I'm not going to extend it at this time unless it's required, because you've not yet signed up for your substance abuse treatment as ordered. That's not a negotiation. The substance abuse treatment will be completed, or you'll do 93 days in jail. So that's the sentence: 93 days Ingham County Jail, that you'll enroll immediately into substance abuse treatment. I want evidence of that within the next 7 days. In addition to that, I'm going to increase your testing to 1 time per week for the next 60 days. Do you have any questions about the sentence?
No, I don't.
Okay, you're all set, sir.
So I gotta you said that something about 4 days in jail?
No, I said 93 days in jail.
Oh, if I don't do the substance abuse,
I'm going to hold it in abeyance to give you an opportunity to get yourself together.
Mhm.
However, if you can't, and I get another violation because you've decided that you were not going to do what you were ordered to do, then I don't have a choice but to put you in jail.
Okay.
Okay?
Yeah.
You should check in with your probation officer, and you're all set for today.
Okay. Thank you.
You're welcome. I think that's all the criminal that I have today.
Yes.
Okay. Who's waiting in the courtroom?
I'm sorry, it was Mr. I'm sorry, can you pronounce your name?
Good afternoon, this is Majidullah Ghansudin.
Wasadin, Wasadin. Defendant for Sparrow Hospital against Wasadin.
Thank you.
Sorry.
The Sparrow Hospital present? I'm not sorry. I don't see them.
No. I don't. And no one's in the hall. Looks like there was a motion to dismiss.
Okay, Ms. Nash, was this matter already dismissed? Well, I mean, was there a default? That's what my question is.
There was, yes, there's a default entered, looks like in August. of this year. And it looks like there was some garnishment of your income taxes.
Okay, thank you. You said the default was when?
It was entered in JIS August 2nd of this
when-
year.
Okay, and when did he file a motion?
He filed the motion November 5th.
On the record, in the matter of Sparrow Hospital versus Magdala Gossading, 24-03003. Sir, please state your name for the record.
That's Michaela Potter, Your Honor.
Okay, Mr. Gossadin, today was the date that was scheduled. This was for a motion to dismiss. However, there was a default that was already entered against you on this matter. The plaintiff did not appear, no representative is present in the courtroom or virtually for Sparrow Hospital, but they did file a response to the pleading. I see your request for a motion to dismiss this case, and you say, sir, that it should have been covered by insurance. What I have here is that you filed that on November 1st, 2024. But however, you served with a complaint in this matter and you failed to respond, and then the default was entered in August. And because of the way you were served, you had 21 days to file your motion to set aside the default, but you waited beyond the 21 days. Why?
Your Honor, actually, English is not my first language. I can speak a little bit, but I cannot read and write very well. When I received the letter from court, the notice, I understood that this is from court, and I called that number, the debt collector. I called them, asked them for more information about what is this for. They said this is for the Sparrow Hospital, but they told me that they don't have more information what is this for. Then I went to the Sparrow Hospital and I told them, what is this for? And they told me this is for like that. My ankle twist. I hurt my ankle. And they told me, I showed them the proof of insurance, medical insurance that I had on that time. And I showed them, they said that we are gonna put this note in the system. So, and I asked them, what should I do next? Do I have to go to court? Because I didn't understand very well that later. And they told me that, no, this is just a notice. So this is not a court date or something. The Sparrow Hospital told me.
Okay, well, I'm trying to understand, just for the record, your English seems pretty good to me. You've communicated, I've not misunderstood a single word that you shared. You received multiple notices for this. You would have received a summons and complaint that told you needed to answer or file an answer within a certain time period. You would have received at least a default from the court indicating a default was entered. And you've gone, you said, to multiple places, including a debt collector and to Sparrow, to find out what it is. Why did you not respond to the court if the court sent it to you?
Because I saw the number like for the debt collector there, and I contacted them first, and they told me to contact the Sparrow Hospital. When I went to the Sparrow Hospital, they told me this is not like a court date or something. So
But you knew to come file a notice to dismiss. You knew to come to the court for that?
no, but that's why I said I didn't understood very well because I learned speaking English like work with friends, but I never went to school here, so I cannot read and write very well. So.
Did you file this motion to dismiss?
Yes.
Okay, who told you to file it?
I asked my brother, and he told me to. You can write this.
Okay, so you asked your brother after after they started garnishing your money, correct?
Yes.
Okay, so I don't think the issue was that you didn't understand, sir. I think that you didn't contact the court timely is what I think the issue is. You wrote a motion to dismiss. You knew to contact the court when your money got taken.
Yes.
Okay, so the only issue that would cause me to have to grant to grant your motion is really because the plaintiff has failed to appear for today's motion. It was scheduled for 2:00. It's currently 2:21. No one's appeared for Sparrow. I'm going to grant your motion, so I'll dismiss the case. You're all set, sir.
Thank you so much. I appreciate
Thank
it.
you. Can someone provide me an order? You're all set. You can have a seat. We'll get you a copy in just a moment.
Thank you.
You're welcome. Ms. Francis?
Good morning, or good afternoon, Judge.
Good afternoon. You were supposed to be here at 2 o'clock for a matter.
I was here since 2 o'clock, Judge.
I called the case. You did not respond.
I was in the waiting room. No one brought me in, Judge. I've been on since 2 o'clock.
I didn't receive any notification that you were in our Zoom room.
We didn't see her in the Zoom room either.
I logged on probably at 1:58
Okay.
p.m. Judge.
Okay, the case was called after the 2 o'clock hour. I think it was about 2:21 when I finally called the case. The defendant appeared in person. The court granted relief from the judgment. He did have his good cause was a language barrier and meritorious defense being that this matter he believed should have been paid for, covered by insurance that he said he provided to Sparrow. So that was the order that was entered by the court.
So is the judgment set aside, or sorry, what relief did you get from the judgment?
The court, he filed a motion to dismiss, which the court actually construed more as a relief from judgment, not motion to set aside default. So you would have to file any other motion. I don't know why, if you were here since 1:58, we wouldn't have gotten a notification that someone was in our waiting room. We didn't get any information.
Judge, I've been on, as an officer of the court, I've been on since before 2 o'clock. I was sitting in the waiting room. I was actually going to call because I know you're usually timely, and then you brought us in. So, but I've been sitting in here. So I would ask that Your Honor reset the hearing date because I have been on. I have no way of communicating when we're when in the waiting room. I don't know why Your Honor did not see me in there.
Okay, the matter can be reset for a new hearing. I have no idea. I have no control over the technology when it relates to the glitches, but I didn't get a notification, and then my staff said they did not see anyone or see you in there either. So we can reset it and renotice Mr. Gosselin for a new date.
Thank you, Judge.
We're going to give you the date now.
That'll be December 16th at 2.
December 16th at 2 p.m.
Thank you, Judge. I appreciate that. I, again, don't know what happened.
I couldn't speak to it either. Or why it would. I guess we can message you when you're if we see you in the waiting room, but I guess it doesn't allow you to message on your own. Is that what you're saying?
Yes, Judge, it does
Okay.
not.
Sounds good. I will see you on December 16th.
Thank you.
You're welcome. Mr. McNeely?
Yes, Judge.
Okay, you're here on behalf of 1 Main. I don't see anybody present for Michaela Potter. Is anybody in the courtroom?
Yes, she's here in person.
Okay, I don't see anybody.
Ms. Potter.
Okay, you're Michaela Porter?
I am.
Or Potter, that is?
Potter, yes.
Okay, so today was the date set for a pretrial. This is a general civil matter. And so the parties needed to complete a joint pretrial statement. Counsel, did you get a copy of the court's standard form?
I did not. I apologize.
I didn't send it yet.
Okay, we'll get Ms. Potter on on Zoom. Ms. Potter, do you have a phone with you?
Yes.
Okay, we'll get her on Zoom so she can meet with you privately, and then my staff will email you the standard form that you all can either complete. In lieu of that, you can also resolve the matter, and then we won't need the joint pretrial, but that's up to you. And for your information, as part of the joint pretrial statement, is a standard form that we use so that we could decide how we need to set your next court dates, okay?
Thank you, Judge.
Okay.
If you have any questions, Ms. Potter, because you are unrepresented, you can let the court know. Okay, it's Michael Ains in the courtroom.
One physically. You can't even see me.
Excuse me.
Hi, Judge.
Hi.
It's Marquita.
You're so
I'm
far.
waving at you.
All I can see is somebody waving so far.
Did you get the scan? Let me, where, can you see me now?
Yeah.
I see you. I got the files.
Okay. That's what you needed, right?
Yes, ma'am.
Okay.
Thank you.
Meet him and put him down. That's what I was like, I don't know who he is. I don't either. Just say Michael Ains.
Michael Ains,
Oh, Your Honor.
She's on the screen.
are you Michael Ains?
Yeah.
You can stand.
Okay.
On the record, in the matters of the people of the state of Michigan versus Michael Ains. This is file number 24-00080. Then I also have people of the state of Michigan versus Michael Ains, and this is file number 17-03334. FY. Mr. Ains, let's first take the 2-4 file. Looks like you failed to appear for arraignment at this for a dog license vaccination that you allegedly received. Let's see. She did not send the citation for the dog license vaccination, so I do need that one, the citation. Let's see, 17-03334, which is an assault and battery. There is a warrant because it said you failed to comply with the collections agreement and that you had a balance due of $660 owed on this file. And so it looks like.
Tell him that. Ma'am, you can't speak, ma'am.
Sir, what happened with your payment plan?
I broke my leg 8 months ago, Your Honor, and things ain't been too good. I got on disability and I get like $950 a month. My lot rent's $553 a month. It's just it was hard to do anything. I had pins in my legs and cast on it. I still got plates in it, but I'm limping around now, but I was pretty messed up there for a while. And money, I don't have an excuse for the money other than I can't work, can't do nothing. I just laying around.
I'm sorry to hear about your leg being broken. And I can understand to an extent how that may have had an effect on you, except for the fact that this is a 2017 file and your leg wasn't broken then.
No, I had been paying on it. That was $1,500 when it started out. It's down to $600. I've been paying only $25 a month. For a while there, quite a while, I paid $20 a month.
Okay, and so I don't see, at least in the information they provided me, any recent payments.
No, I think she said August was like the last they heard from me. But I used to come up here to the 6th floor and give the guy over there my $25 every month.
What does JIS say for his last payment? The ROA they sent me
Last
said
payment
2022.
Was August, no, it was August 8th, 2024.
Okay. Okay, so you're on disability now, sir?
Yes, ma'am.
Okay. Is it because of you don't expect it to be permanently disability, just, is that because of the broken leg, or what's your plan,
I
sir?
hope not. I did turn 65, so, you know, I ain't getting any younger. I laid carpet for 40 years. I don't know if I can do that much more anymore, much longer.
Yep, that you were self-employed as laying carpet is what it says. I am just trying to understand what the remaining fines are for here. Let's see. Okay, is there a breakdown for what this balance is for in the file?
Okay.
And then
Trying to look.
Judge Clark fined me 1,500. Shocked that it was so much, because
Okay. Yeah, you can have a seat, sir.
thank you. My mom's behind me here to help me out, but get what I was gonna say now.
Your mom's there to help you out, help you walk, or help you with what, sir?
Oh, just help me, you know, in case you want to throw me in jail or something. I don't know.
You're here for licensing and for failure to pay a fine. We're not throwing you in jail for that.
Oh, thank you. I get a little worried now and then.
Judge, his notes, they're not very clear as far as the breakdown.
If you scan it to me, I can probably figure it out. What it was in Judge Clark's handwriting.
Yes.
Yeah, if you can, I can try to figure it out while you scan that to me. The other matter, sir, I do have the citation for the other file that you failed to appear for arraignment on back on January 4th, 2024, 9:23 in the morning. The allegations that upon the area at or near 70558 Kipes. I'm not sure how to pronounce it.
Hippie's Court.
Hippie's Court. Okay, sounds like you're familiar. In city of Lansing, Ingham County, state of Michigan, that you allegedly had a unlicensed dog. So that's a misdemeanor, sir, and you do face potential jail time if convicted of unlicensed dog. You have the right to have a attorney represent you, and you have the right to proceed to trial in this matter. The citation identifies the dog as the name of Buddy, a white tan male pit mix, indicating that there was no proof of license provided at the time of interaction with law enforcement, Ingham County Animal Control. And so you have the right to have an attorney represent you. If you can't afford to hire an attorney, you can request to have the public defender's office appointed to represent you for this matter. You understand that, sir?
Yes, ma'am.
Did you want to request the public defender to represent you?
I don't think so. I just, you know.
Okay.
Soon as I can get in.
Well, let me just stop you because you have the right to remain silent. So anything you say, anything you put in writing could be used against you. And you do have the right to plead guilty, plead not guilty, or stand mute. And if you stand mute, the matter is going to continue all the way to a jury trial. Again, you could go all the way to jury trial on this matter because that's your right. And you could require by right the prosecution prove each element of the charge being brought against you beyond a reasonable doubt. You can remain silent at trial, not have silence be used against you. You can subpoena witnesses that could testify for you, and you have the right to question or cross-examine any of the witnesses that the prosecution calls in this matter. And so for the purposes of today's proceeding, which is a walk-in arraignment, I'm going to enter a not guilty plea on your behalf. I will note that you are requesting to represent yourself. The typical way in which the licensing matters are handled by the county prosecutor is if you provide evidence that the dog is licensed, they'll dismiss the case. They'll give you an opportunity to go get a license if you needed to do that. Or if you no longer had, let's say you no longer have the dog was surrendered or it wasn't your dog, they'll take evidence of that as well to help resolve the matter. So we will enter a not guilty plea for you, and this matter will be set for a pretrial so that the prosecutor's office can be present, and you are able to appear via Zoom for that, as long as you have video. Do you understand that?
I don't know how to do that stuff, Your Honor.
Well, then you can appear in person. I'm just giving you the options.
Okay, I'll come up here.
Yeah, you can do either way. We'll get you your next court date right now. What's that date?
It's December 2nd at 10:30 with Judge Buchanan.
December 2nd at 10:30 with Judge Buchanan, okay?
Yes, ma'am. I'll
Okay, and
be sure to be.
very good. And then as to the amount of money that you were owed, oh boy, let's see here. I think it was
Check traffic tickets. I bumped somebody and I didn't have to prove insurance.
This is seemingly attached, however, to a home invasion and assault with a deadly weapon file, not to that. I think you pled to an assault and battery on. I don't see. Was there a collections file for this?
There is a collections file inside the file. Yeah, she's trying to see the breakdown.
I'm trying to figure out why he owed this money.
Judge Clark fined me $1,500 and I had been paying on it.
Okay,
Still,
sir, I need you to be quiet while they find in the
Okay.
file they're supposed to be finding.
I see that. I just don't know what the fines were, because there's like, Judge, there's the $50 state cost, and then there's like $195 in fines. And then
What are you-
600.
What are you
Go
reading?
ahead. The JIS. There's nothing in the file that has a breakdown of the fines.
Though the
cost.
fines is attached to this particular file.
Yes,
Well, then that
it's
means
just this one.
there should be a typed up judgment of sentence. And that judgment of sentence will tell me what the fines are for.
I see. Looks like he was on probation, so it was breakdown. Some of that might be
I need to see it.
okay, because it's not
Can I say something, ma'am?
clear.
Judge?
Yeah. Yes, sir.
Good. Judge Clark, he sentenced me and he fined me. Then he sent me to Sacred Heart. I think I left there early. I didn't
You
complete
did.
it.
I saw all that. I see all of that in the file.
Do you?
Yeah.
So I did 90 days or something on it, didn't I?
It said you did.
Thought that would pay for my fines
That's why I
for
want.
that case.
That's why I'm looking for the paperwork to see what this money is attached to.
Thank you.
Okay, he sentenced you 1315. There was a fine of 195, cost of 455, supervision 540. September 25th, 2017 is when this judgment of sentence was entered. However, December 6th, 2017, he terminated your probation. So less than 2 months or 3 months. Less than 3 months, your status was terminated because you didn't complete the programming. 93 days, Ingham County Jail, credit 59, which means that the oversight fee should have been waived.
That's what I thought. I've been paying on it for a long time. Not lately, since August, I think the lady told me this morning on the phone.
And then even the way that this judgment of sentence was typed up wasn't accurate. They put fines and costs 650. That can't be right, because let's
All
see.
due respect, I was a little worried with Judge Clark right before he
Okay, but
retired.
we're not here to talk about
I know.
or disparage a judge. I'm here to clarify what your sentence should be. Okay, oversight fee. Ms. Nash, is there a penalty that was added for not paying? Or is that just all the remaining balance of the cost?
I'm sorry, I'm trying to look on the ROA.
No problem.
Yes, there was of $132.
Thank you. Okay, that'd be 18 months probation, but you only really did 2 months. Because you was terminated after that, so
I didn't do so hot, did I?
you didn't do a great job, but hopefully you've learned since then. I don't know, but I'm going to waive $480 of that because that was oversight fees that should have been waived.
Thank you. Very much.
When are you gonna pay the balance, sir?
Depends on what it is, and my mom,
I pay it today.
she's gonna try to pay it today. Right. And you know about the 2 tickets too, right? Or no?
No.
I don't
it's not.
know anything about the 2 tickets. They gave me 2 files here today.
Okay.
There was that citation and then this file. They didn't give me a ticket. So if you do
Right.
have a ticket, I don't know what it is, or it must not be in warrant status is what I'm assuming.
They're
No,
not.
Right. The lady told me 2 tickets were 500 and something altogether. Insurance, no insurance and some bumping into somebody. No damage.
Okay, so yeah, they're not in warrant status, so that's why we won't address that today. So you probably want to take care of those another time. You can likely resolve this matter. It says that your balance was 660 was originally the balance,
Sounds about right.
and I just waived 480 of it. So the balance is $180.
Thank you.
Will that be paid today, sir?
Yes.
Okay, I'll note that you'll pay it today. That'll resolve this matter, and then you have the matter that's before Judge Buchanan. You got your notice to appear, and then you can resolve your citations for traffic outside of this. Okay, sir, do you have any questions?
Judge,
No, ma'am.
Yes.
Thank you very much.
in JIS, it says it was $792. I just don't know if you took off the late penalty. Is that why it was $660?
The bench warrant said it was 660 on the bench warrant. You said 660 plus, how much did you say it was? 132?
32. I believe.
Yeah, that's because the late fee was on there. You can waive, I'm waiving.
Okay. Okay.
So they'll pay 180 today and I'll waive the balance.
Okay.
Thank you.
Okay, you're all set.
Thank you very much.
Will they know out there is that we're gonna
Yes.
pay?
You will,
Yes, they will.
yeah, well, they'll note it on the file and bring the file there.
Thank you.
Okay, thanks.
Judge, did you say the bond for the dog license?
100 personal recognizance.
Okay.
Thank you, ma'am.
Thank you. I gotta log off so I can go to my.
Sorry to call you ma'am, Judge.
Thank you. You're all
Right.
set.
Okay. Mr. McNeely and Ms. Potter is back.